session. And this is Anika Sharma, your moderator for today's session. And I have been working with Amikus Qriae for last few months. And today I welcome you all on behalf of Amikus Qriae to this virtual webinar on to this 2-day national workshop on art of memorial drafting and skills of argument in moot court. So a lot of people here might not be knowing what amicus curiae is and how it works. So for them, I would like to introduce to you to amicus curiae. So amicus curiae is the brainchild of several legal luminaries and eminent personality across the country and the globe. The Amicus Curiae is a dream online platform which aims at proliferating legal knowledge and providing an ingenious understanding and cognizance of various fields of law to make sure that legal knowledge and experience penetrate to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, the Amicus Curiae aims at providing valuable contributions to contemporary legal issues and developments in the omnipresent field of law to the masses. And now, Amicus Curiae is also a Ministry of MSME Government of India recognized and an ISO certified organization. So today we have Advocate Arish Visruth to enlighten us on the art of drafting, memorial drafting, and argumentation in a moot court. He is he has completed his BLLB from University of Kerala in 2013. Then he completed his LLM from National Law University Bhopal in the year 2014. He then practiced as a lawyer in Kerala, in the High Court of Kerala. Then he has been a PhD scholar in the Department of Law, School of Legal Studies, Central University of Kerala. He has been a part of various moot court competitions and won them as well. He was a finalist at first national moot court competition at Sheshadipuram Law College, Bangalore. Then he was a winner of national round states and international environmental moot court competition held in Bishop Cotton's Women's College, Bangalore. He was a runners-up at national moot competition held by MP Law College. He was second runners-up at national moot court competition on competition law organized by ULC Law College, quarter-finalist at national moot court competition held by GLC Ernakulam, runners-up at national moot court competition conducted by Savita School of Law, Chennai. Has further won various debate competitions, has been a participant in quiz competitions as well. He was second runners-up in LTS Dispute National Debate Competition 2013, held by National University of Advanced Legal Studies, Cochin. He was winner at National Environmental Quiz Competition held by Government Law College, Thiruvananthapuram. He has a great judging experience. He has been a part of various moot court competitions, client counseling competitions as a judge as well. So he has judged the Juris Corp Corporate Law Moot Court competition organized by NLU Bhopal. He has also judged the Tanhaka Memorial National Moot Court competition, which is also held by NLU Bhopal. And he has also judged Kerala Law Academy Law College. Kushal, would you just turn off your mic? Thank you. He has also judged the Kerala Law Academy Client Counseling Competition in 2015 and 16. He then judged the Kerala Law Academy Law College National Moot Court Competition in the 2016. He has been a judge at ADR competition in Government Law College, Thiruvananthapuram, and he has judged the intra-batch competition for the selection of National Pool Selection 2018 Mar Georges College of Law, Thiruvananthapuram. And the list might have went on if I have not stopped here. So now I am limiting myself to this, and I would like to request so to take over and begin with the session.
Good evening, Anika. Can you hear me clearly?
Yes.
Right. So can we start the session without wasting much of your time?
Yes.
All right. So let me share my presentation. Anyways, uh, once again, thank you, Amikus Qriae, and yourself, Anika Sharma, for giving such a very good introduction about me. It was a pleasure hearing all those experiences. Been there back sometime. Anyways, let's start with the presentation. You can see it, no?
Yes, sir.
So, before I start with my presentation, let me tell you one thing. For all the speakers here, so I have been asked to give the presentation in 2 days, for today evening and tomorrow. So I have divided the presentation as such in two legs also. As in, today I will be dealing with the memorial drafting skills in Moot code, and for tomorrow's presentation, I have reserved the skills of arguments or oral presentation to be taken care of. So, start with today's presentation. I guess you guys may be aware of mood codes, but still, I should tell you one thing that mood codes, from my own experience, I'm saying, since the time I was in mood codes and right now when I'm practicing in the various codes in here in Kerala, what I felt is the mood code throughout my academic career has helped me in developing my lawyering skills. Lawyering skills as to how to prepare for a case, how to analyze a legal problem, how to draft the issues, and how to research upon the same, and then as to how and where you should use what all methods to be used during your oral advocacy by legally articulating you to help you develop the legal articulation skills, and also in honing your legal persuasiveness. So with that, let me tell you. See, moot code, as you might all know, it got two stages. The first stage, wherein you prepare the memorial and submit your written argument, and the second stage, wherein you go for the oral presentation. So, regarding the memorial preparation, when you go, I should say, I have divided it into three particular stages. First is the initial study, wherein you deal with the moot proposition as such. The second one will be dealing with the planning of research, and the third step will be about the researching skills. In the initial study moot proposition area, what you need to take care of is you need to find out the boundary within which you have to argue your moot proposition. For that, what you need is you need to read your moot proposition again and again, multiple number of times, so that you yourself are well versed with the facts to the core, and that will in fact help you in finding out three particular things. First one, identifying the material and immaterial facts in the proposition as to which are the facts that will help you in winning your side, whether as an appellant or as a respondent, and which are the immaterial facts that you need to avoid or not to give that much importance so as to save your time while preparing the memorial as well as during your oral rounds. Now, the second step would be identifying the keywords. By keywords, what I mean here is those particular crux or main component in the mood proposition, which will help you in narrowing down your research. So, through the same, what you will be able to do is you will be able to understand as to the points which will be supporting your case, both sides, as well as the points which stand against your case in both appellant as well as the respondent. So you need to first be very much thorough about your moot proposition. I have seen people going through the moot proposition just once or twice and saying that they are well versed with the facts. But I should warn you, when you do this, what happens is there are high chances for you to miss out the probabilities or the hidden facts given in, which you might have been able to use it in such a manner that your argument might have been articulated in favor of you with much ease and without any pressure. So what you need to do is, once you read on your mood proposition, go through it multiple number of times, find out those facts, identify the keywords, then those based on that keyword, again find out which are the material and material facts which support your case. And now you need to write it down it in a chronological order. So as to make a clear-cut relation as to the facts or the incidents happening in the proposition. Then you need to make a blueprint. You need to make a blueprint in which a maximum of 3 to 5 facts in numbers should be taken to support each of your contentions. These 3 to 5 points will act as the pivotal point around which the whole argument of your presentation will be based upon. The rest of the facts can be used to build up the arguments, but still these 3 to 5 facts which you find out from your mood proposition should be the main facts or the blueprint upon which you will have to build your arguments. Now the second stage regarding the planning of research. What happens here is you need to identify a central theme of the case. As in, for example, if you are doing a mood on the mood proposition is if it is on a law of crimes, and say the incident which was given as regarding the which is the law here, the central theme, as in the jurisprudence behind the case. As in, if it's murder, you need to know about section 300, section 299, section 302, and everything related to that. You need to know the main differences between these sections. The sections, the provisions in law should be very much clear cut to you without having any chances of confusion for you. So, as I mentioned already, in the initial study of the mood proposition, you will take care of the factual side. When it comes to the planning of research, the second stage, here you all need to bother about the legal side, wherein you are behind the jurisprudence behind the case. So through that, you need to find out the appropriate laws or provisions supporting the problem or your fact sheet. And based on the same, you have to in fact make a normative framework by using the facts and the procedure law that you have at hand. Alright, so moving on to the third step, what happens in researching is it's an implementation of the step 1 and step 2, I would call it. Because in the two legs, you have identified the factual issues which will be supporting your case, which will be helping you build your case in favor of the appellant for one side and for the respondent the other. And in the second step, you identified the jurisprudence, the main legal provisions supporting the same. So what you need to do in the third step is, when you start your research, you divide it into 3 areas. First one is regarding the factual mood proposition, wherein you have to find out answers for 3 queries. First, what has to be proved? Second, how will you prove your case? Third, how will you disprove your opponent's case? So these 3 factors should be taken into consideration. And how to do this? To do this, you need to collect facts supporting your case. You need to draw inferences from the preliminary facts given in the mood proposition. And you need to formulate a hypothesis. So once you're done with that stage, the second leg of the research would be dealing with the legal or the jurisprudential side, wherein you go through the bare acts or provisions. If, for example, it is an international moot, you go through the conventions or treaties or the opinion of the jurist or the literature about the same, about that provision of the convention. When it comes to a national moot, you need to find out the municipal law which deals with it. Go and read the Bear Act, find out what is given there, understand the nuances of that Bear Act, the provisions in the Bear Act. To go in deeper, go and read and find out the substantial points given in the commentaries, commentary book of the Bear Act. Find out those arguments which will support your side.
Now, what you need to do is, once you are prepared with all these things, you need to research and find out the provisions which support your case, and through which you have to discover the more sections or laws which will strengthen your case. So once you're done with this particular step, you can move on to the third leg of research, which is the case law search. Through the case law search, you can depend upon any of the legal sources like Manupatra or SEC online, from which you can find out the case laws if it's a national moot. And I would suggest that you do require quite some amount of time in researching the case laws, because you need to find out the first case to the most recent case in the area, in the matter which has been dealt in the moot proposition. If it is a novel area, if it is a new area, as in a new legislation which is yet to be disputed in the Supreme Court, then instead of being dejected at your mind, you should be taking it as a challenge. And instead of depending upon the case laws or precedents to support your arguments, what you can do is, you can in fact be very much innovative about the arguments that you can frame and argue in front of the court to support your case. So that's how you learn yourself to be a good lawyer. So once you complete these steps, these three steps, as in working out with the moot proposition, as to finding out what has to be proved and how will you prove your case, and doing this by collecting the facts supporting your case, drawing inferences from the preliminary facts and formulating a hypothesis, and thereon moving to the bare acts, finding out the legal provisions supporting your case, then to the case law, wherein in a chronological order, you start developing the jurisprudence in that area as to how this particular law has developed through the case laws over the period of years. Read it, study it, understand it, and then it will help you to start writing your memorandums. Now, as I already mentioned about this, the moot problem. Now let me tell you as to how you need to frame your issues. So what we used to do is, we used to follow a golden rule, that the IRAC rule. I stands for issue, R stands for rule, as in the law and the precedents, A for argument, and C for conclusion. So through this, what we do is, this is how we fix an argument inside the memorial. We find out the issue first. We find out which is the law, legal provision or rule which applies to that case. Then we also find out the case laws supporting the same. And based on the same, we start writing the arguments. And mind you, never write your arguments in a memorial, as in you are writing it in your argument notes for presentation. You never do it on first person. Never ever do that. Because nowadays, whenever I get to see any of the memorials for memorial corrections, it has come to my notice that the standard of memorial writing has drastically reduced. And it's not just my opinion when I say this. I've talked to a lot many judges who used to judge since the time even we were in college, and even they also have the same opinion regarding. So most of the time what we get to see is, when they write down the arguments advanced, they just write it down as in a very plain, simple terms, as in they are arguing. They are just writing down as in the format of an argument note. I'm telling you, an argument note is highly different from what you need to submit through the arguments advanced in a memorial. In an arguments advanced, you write down your case, you frame your case, you find out the issue, You first start writing through the legal side, then connecting it with the factual side, and comprehending the whole arguments by concluding as to what you need through this particular, what you want to get through as the release. Now let's see what are the contents of a memorial. You see, the standard memorial contains generally these 10 things. Definitely, we do have annexures or appendix attached to that based on the problem in which we are working. But generally, we do have all these things: the cover page, table of contents, list of abbreviations, index of authorities, statement of jurisdiction, statement of facts, issues raised, I should say, summary of arguments, arguments advanced, and prayer. Now let's see. See, in the cover page, I'm telling you, you need to take care of these 5 things. First, name of the forum in which you are arguing that matter. The moot proposition will definitely give you a forum in which you will be arguing. So make sure you never miss out this, because sometimes what happens is when in the last second you organize a memorial at the time of the last day or deadline of submission, what happens is most of the times some errors happen in the cover page. And mind this is the first page a judge gets to see from your side, even before you present your case, even before you argue anything in before the judge, or even before you say the first word in the court. This is the first page the judges get to see, depicting your research and your team. So this is the first impression of your team before the judge. Think of that situation when any of the main particulars in the first page itself goes wrong. As in, I have seen multiple times when the teams, they have written down the name of the forum in a, as in if it was before the Apex Court, instead of writing before the Honorable Supreme Court of India, they might have confused it before Honorable High Court, all because of the reason in that particular problem, the matter was first contested in High Court, then taken to Supreme Court. Okay, hope you're getting that point. So make sure that name of the forum is never ever mistaken with. And second is the name of the case. Here also what happens is a multiple number of times I have seen the parties confusing themselves with the appellant or the petitioner and the respondent on the other side. Say for example, X happens to be the appellant or petitioner and Y happens to be the respondent. So sometimes what happens in the moot proposition it gives, they're like in the first court, on the first forum. For example, say High Court, they approached the High Court under Article 226, the jurisdiction of High Court. So say Y was the appellant there and X was the respondent. And it was, allowed or rejected, something happened. And again, the same matter was taken to Supreme Court under 32, because Article 32 does not attract res judicata. So definitely they can go to the Supreme Court for a fundamental right violation. So the parties might have changed there. So I have seen the teams getting confused about this. They might have been very well versed with the facts, but they got confused when writing down the names in the cover page. So it actually gives a wrong impression before the judge. The judge gets to feel that you are not serious with your case. Had you been serious, you wouldn't have done this. That's what the judge will presume. So every single time you write down any of these things, be sure that you don't commit a mistake there, right? It might feel very much of a trivial matter for you when I write down all these things in the slide, as in the name of the case, title of the memorial, and jurisdiction involved. But when I say this, believe me, many times I have seen the teams committing mistakes wherein they have written down the jurisdiction in the wrong manner, and even the title of the memorial, as in they want to appeal for the matter and they might have written down in respondent. So make sure such a mistake doesn't happen. Now, when coming to the table of contents, I should say this is the index or the structure of the file that you have all written, okay? Because a judge, once he turns the page, just after the cover page, he gets to see the table of contents. Going through the table of contents itself, he will get an idea, he should in fact get an idea about the structural format, as in how you have advanced your arguments. So there what you need to do is, you need to break down your arguments into contentions, then sub-contentions and subheadings. As in, say, if the first contention, whether the writ is maintainable under Article 32, then the second heading should be, you should have a sub-contention saying that this is the reason why the writ is maintainable. And if you have something else to prove there, as in, say, substantiating the locus standi, then you will have to give it into a subheading. So through which through the first page of table of contents itself, the judge will get to understand as to, okay, this is how the team is trying to put forward their arguments. Right, let's see as to how they go. And now, when coming to the list of abbreviations, why I wrote down as to only those used in the memorials and no CCP. CCP, I mean cut, copy, paste. Because many times I have seen the teams just copying down the abbreviations from some other memorials. And what happens is it was a international moot, and you get to see the abbreviations related to IPC, CPC, CRPC there, of which there's nothing no relevance at all in that moot proposition. So don't do that. Whenever you write down a list of abbreviation, even if there is one or two, or even if there is just one, whatever it be, you take it down from whatever you have written in your arguments advanced. Never ever copy paste it from some other memorials. It may lead you into trouble. And the judges do definitely ask you questions about these, especially in the case if the judge is an ex-mooter. So he will be more interested in the technicalities there. So he will caught you red-handed in these technicalities and will confuse you and will, take a lot of your precious argumented time there. And second thing is, whenever you write an abbreviation, use always follow uniformity in the same, maintaining the same. As in, if you are writing, for example, and if you are using a particular symbol for that, make sure you are using the very same symbol from the first to the last of your memorial. Now, when you come to the index of authorities, what you see here is you need to have a structural format. Structural format, as in, you need to write down in an alphabetical order as to the articles that you might have taken, books, cases, journals which you might have depended, parliamentary debates, if any. So whatever you might have taken as an authority, you should show it there very clearly in a chronological, in an alphabetical order. So this part of your memorial, in fact, helps the judges to identify as to how much or what amount of research you might have done. Because once going through the authorities, if you have cited all those cases right till the, that particular month of your presentation, as in if you have got the most recent cases in your authorities cited, then that itself makes a good impression before the judges. They just start feeling that, okay, they have gone through, they have kept themselves updated and not limited themselves to the 1950 and 60 decisions. I'm not telling that you shouldn't depend upon or you shouldn't, cite any cases from the 1950s or 60s. You should do that, definitely, provided those cases are of much relevance to your contention or to your problem. But otherwise, however big your contention is or however small it may be, if you could cite it with something very recent, very much relevant, whether it be a case law, if you don't have a case law on the same, whether it be a research study or even a research paper done on the same at the most recent times, then that would support your cause. That would help you in building a great impression before the judges. Now, moving on to the next slide, statement of jurisdiction. Anika, I'm clear to you, right? I guess you can hear me clearly.
Yes, sir. Yes, sir, you're clearly
Please,
audible.
someone could respond. If you could.
Sir, I'm audible to you?
Yes,
Okay.
sir. Yes, sir, you're audible.
Okay. So the next point will be the statement of jurisdiction. See, the statement of jurisdiction, you just write down as to which particular jurisdiction are you invoking in this case for which particular court. So most probably, if it is a special petition, you would be saying that it is an article under Article 136 of the Constitution of India. You are invoking the special jurisdiction of the, special petition before the Honorable Supreme Court. So that will just generally, it's in the nature of a formality, and you write it down in a single sentence. But the things that you should note down when you write down the jurisdiction is, see, in your memorial, they won't be asking any questions, except that you commit a mistake regarding the jurisdiction. At times, even though in number it is very less, but at times, teams did commit mistakes regarding the jurisdiction cited. But so make sure that you didn't commit that mistake. But apart from that, what you need to know when you cite the jurisdiction which you invoke in that case, you need to know as to why that jurisdiction is being invoked. For example, if you are citing Article 136, special leave petition. So there are two grounds in the special leave petition, which states it as to when and how the special leave petition can be granted. It also states that special leave petition, unlike the writ jurisdiction, it's not a matter of right of the petitioner. It is a discretion of the court. So you need to know about these nuances. Okay, every time you cite, for example, if you are taking Article 226 as your jurisdiction, you need to know that the High Court's writ jurisdiction is wider when compared to the writ jurisdiction of Supreme Court. But at the very same time, High Court won't entertain a writ petition under Article 226 if an alternative remedy that needs to be exhausted is not dealt with. So you need to know as to the various legal positions, the most updated legal position of the jurisdiction. Now, regarding the statement of facts, it's just a summary of the relevant facts. But you should never ever presume the facts, as in if they have, kept something vague or not clear in the fact sheet, that doesn't give you the freedom to presume facts and frame your arguments upon the same. Because if you do that, you will definitely repent upon the time when you go before a good judge, who will definitely get you, into your trouble by twisting the facts, and you will have to presume more and more, and finally your case will fall apart. So never ever do that, because even this thing helps as a training for you all throughout your litigation career. Also, you will get to learn this. You never presume facts when you build your case. Okay. And regarding the statement of issues, when it comes to that, you introduce the issues as a normal single sentences. And normally you do start with as to whether, using the term whether the Article 32 is maintainable, whether Article 226 of the High Court of Jurisdiction, High Court of this particular some state is applicable here, like that. So whatever be the statement of issue that you are citing, there should be clear-cut precision regarding the issue. And if at all needed, if you have divided your contentions into many sub-contentions, then only provide the subheadings. Otherwise, no need to be worrying about the same. Now, when it comes to the summary of arguments, it is all about the gist of your argument. So you just point out the best of the arguments that you might have noted down in the arguments advanced. And I will tell you what is the relevancy of this. See, when you go to the litigation career and when you start practicing, you will get to see this. If you're presenting a case before the High Court, there you need to give a gist of the facts, wherein you will not be explaining the whole facts. The whole facts may even go around 15, 16, 20, 25 pages or something. But the first summary, as the name states, it's a summary. It's supposed to be a summary only. You write down in a couple of paragraphs or at least 1 or 2 paragraphs as to what happened. And that will be the one upon which the judge will be having an idea as to, okay, this is the matter that we will be taking care of. So why I am telling you this, if you notice all these small, it might feel very small for you, all these particular things that I have been telling you. But if you notice all these things and if you make sure that it is being drafted in such a beautiful manner, then definitely it will attract the impression of the judges. Now, coming to the most important part in a memorial, the arguments advanced. This part actually reflects the research done by you. So this is where you need to be cogent, clear, and precise in expressing the intention of the side which you are representing. As in, you have to systematically structure your argument. You need to establish the nexus between the factual and legal provisions. So that's where I stated, when you write down the contention, whether the Article 32 is maintainable here, then you start saying as to why, what is Article 32? How is it relevant here? What are the things which will be taken under that? So you will state all these things in connection or in support with the authorities, not by all by yourself. You need authorities to support your case. And once you do that, you can cite down the case laws starting from 1950 till 2021. You can write down any number of relevant case laws. And finally, you write down the factual arguments regarding that particular contention. And you will say as to how these arguments are connected to the law that you had been stating in that particular issue or contention. And based upon the same, you need to highlight the main or the pivotal point of arguments, both legal and factual. So I would say, to follow down a standard format, it would be better if you start with the law or bare act provision. Then you get the case laws in support of you, the precedents. And finally, you add on the factual arguments supporting the issue at the final length of the contention. So that would clearly help you in showing the connection or the nexus between the factual and legal provisions. And at the time when you wind up your argument, the argument should be done, the winding up of the argument, it should be done in such a way that that particular paragraph comprehending as to why or how your contention or issue is substantiated, connecting the legal and factual side, establishing the nexus between them. So this is the most important thing to be taken care of when you write an arguments advanced. And also, you also need to note down one more thing, that as I mentioned at the start of my presentation, that arguments advanced is different from the argument notes that you carry around with you when you do the oral presentation. During the oral presentation, from the argument notes, you start presenting it as in you are representing the counsel. So you'll be using all those terminologies as in the first or the third person, but that's not how you write down an arguments advanced. You write it down in a most systematic way. You'll get a copy of a best standard memorials in the internet, including whether it be the national or international. It's available in a lot many websites. Go through the standard formats, understand as to how the paragraphs are being framed, the sentences are being structured, and based on the same only, write down an argument. Okay. Now, one thing that I need to tell you is, see, when you write down the arguments, the headings of the arguments, in fact, can be taken care of in a different way, which will help you attract the judge's attention. For example, you need to write it in caps and all bold letters as to those contention, which is an extremely important one. For example, if you have it is a main contention, write it down in all caps and bold. When you have a sub contention, then I would say leave the caps part, just write it down in bold letters. That will make it important to the judge. He will understand. And why we used to have headings in italics, if you ask me, I would say it's because of the reason that the italics helps in organizing or in helping you organize to get an idea as to what you are trying to substantiate to through that point. So these are the simple or a very, say, very simple or silly things which could have helped you bag a best memorial at all, right? So moving on to the final stage, wherein you state the prayer. See, you might think that what is there much to be talking about the prayers? But the thing is, I have seen a lot many teams committing mistakes in prayer. As in, I have seen a team arguing very, very thoroughly for the appellant side. They did it in the best possible manner. But when it came to the prayer, due to some mistakes or something, they have written down at the bottom of the page that the prayer, the counsel for the respondent submits like that. When in fact, they have argued for the appellant. So they tried to justify their side by saying that it was a clerical mistake. But the clerical mistake would stand in a court of law. Think of that situation when you had committed the same in front of the apex court while you were literally arguing before the Supreme Court. Will they admit this? No, they would never do that. So if anything of that sort comes over there, it will definitely affect your marks, even though you have done a good presentation. And the second thing is, whenever you write down a relief or a prayer, most of the teams just keep it themselves confined to the contentions they have raised as the issues in the arguments advanced and all. You can do that, but whatever it be, make sure that it is clear and to the point. You need not drag it to an unnecessary end. Now, these are the general legal research portals that we depend upon while conducting research, starting from Westlaw, Keen Online, SEC, Manupatra, JSTOR and all. So Manupatra deals with the case laws mostly, and JSTOR you get to have a lot many qualitative journal articles. And yeah, this is one thing I need to tell you. Whenever you research a case law, you need to be aware about these four things, because the judges generally they ask you about these four things whenever you cite a thing inside the memorial or during your arguments. First, what are the facts of the case? If the facts of the case are very similar to your case, then it's okay. If it is not, then the issues involved is the one which will help your side. Because every single time you may not find those cases having very similar facts to the one that you might have in your moot proposition. But that doesn't matter. If the issues taken in that precedent is, the questions raised in the precedent is very much in support with yours, then that will help your case. So you need to be aware of the facts of the case, the issues involved, and definitely what is the ratio decidendi, as in the reason for the decision in that particular precedent. You need to cite that, and the final judgment, whether the judgment was in favor of that petitioner or in the respondent. Okay. And when I cited the ratio decidendi, that reminded me about something else. You need to have a basic idea about the the legal terminologies as such. If the judge all of a sudden asks you what is the difference between obiter dicta and ratio decidendi, you need not fumble. You should have an answer for that, because that is something which is expected out of a mooter to speak out, whether it irrespective of the case, whether the moot is a national one or an international. So you need to be thorough about the legal terminologies that are in use. Now, to give you some general tips regarding the memorial preparation, you need to identify clear writing. I'll explain as to what I mean through clear writing, because I have seen teams working in different patterns while drafting the memorial. For example, I've seen a couple of teams working dividing the contentions between them, as in if they had 4 contentions, the 2 contentions will be dealt with by one speaker, 2 by the other speaker. The researcher will help both of them in finding out the arguments. But I have also seen teams working in a different manner, as in one speaker will work for the appellant. He or she will prepare all the contentions for the appellant. The researcher will assist, and the other speaker will find out for the respondent. I'm not commenting upon which is going to be the most successful case, but it depends. Even if you write down in either of this manner, you're supposed to study the contentions for both the sides when you present. So it depends upon your skill. If you could study that contention which you might not have prepared but still perform well, then it's okay, fine. Then it's up to you. But whatever it be, you need to identify a clear writing skill or writing practice or strategy among the team members. Because what happens is, if one of the speakers is a good writer, if she or he is able to draft it in a beautifully drafted manner, and the second speaker, if he or she couldn't make it up to that level, what happens is the moot, your memorial itself will not balance. When the judge goes through your memorial, he will find out that, oh, he will start doubting the quality of your memorial when it varies drastically. So even if one speaker or researcher couldn't identify or draft the contention in a substantial good manner, I would say always remember one thing: moot court is a matter of teamwork. It's not a one-man show. So the team needs to work together and they need to identify clearly in writing down and framing and structuring their arguments. And always be open to changes. As in, you might have researched for around 1 month or 2 months for finding out a particular case law or a legal position. And on the last day of your submission of the memorial, one of your teammates comes up with something new, which in fact is an updated position in that particular area of law. All because of the reason that you might have invested a lot of your energy and time in finding out the things that you might have drafted down in the memorial. You shouldn't limit yourself by not letting that person have that updated, legal position being written down in the memorials. Because what happens is you might be happy with what you might have found, but the judge might not be happy with you sticking on to a old position which might have changed. Okay, the case varies. If after the date of your memorial submission, if a new law comes into place, that's a different thing. But otherwise, be open to changes or corrections till the last moment. And always make sure that you proofread your memorial n number of times, including the spelling checker and maybe taking care of the use of Grammarly software, something like that. But to make sure to avoid the inconsistencies and errors in your arguments. And even though usage of flowery language is, good and impressive, what happens is that may not, however, attract points every single time. Because maybe the judge is not happy with the way you might have drafted that in a flowery way. You might be thinking that you might want to write it down as in the way Justice V.R. Krishna might have wrote down a judgment. But I would suggest you can definitely write down something of that sort, provided you give yourself some time so that you get into practice and get yourself elevated to a constitutional bench, and then you can write down something of that sort. Or maybe you can write it down through a legal research article, even during the first year of your academic studies in LLB period. But moot court memorial is not the place to show off your English language skills or flowery language terminologies. Because most times I have seen people getting caught and completely ruined by the judges, all because of the reason they might have cited something in a very flowery way, and the judge started interpreting it in a different way, even though the presenter wanted to interpret it in the fashion he or she might have written down. The judge is at liberty to take a different interpretation, and if he substantiates it with some other thing and the whole case goes down, anyways, it goes against you. So it's always better to use simple English. And usage of legal maxims is generally promoted. That's a good thing. Even I wouldn't go against that. But avoid using too many maxims. Too much of anything is not going to do good for you. In fact, it will be harm to you. So, and the most important thing, that is formatting. The beauty of the memorial, I should say, lies in formatting. Because you need to follow maybe if it's a blue book citation given in the rules and regulation of the the moot court competition, follow that blue book citation, 19th or 20th edition, whichever it is. If it is something else, follow that. Whatever it be, do your formatting in the best possible way so that your memorial will look in such a beautifully drafted manner, which will make itself attractive to the judge, even though he is just passively running through the pages. So that's all with my presentation. If you got any queries, anything related to that, I'm more than happy to answer. Okay. I see we
Yes, so
got
there are
questions here,
some.
right? Yes, Anika, I
Yes,
saw the
sir.
question. Sir, can you please once more tell about the argument part? How to create a strong argument? Okay. See, that's what I had been telling you. Whenever you draft your arguments, you need to divide it into three parts. The first is the legal part, the jurisprudential part, which supports the contention. You need to find out the law, the provision, if it's an international moot, the convention or the treaty, which provision from that convention or treaty supports your case. Then you need to substantiate it with the legal commentaries. You need to look into the commentaries written down by the jurist or through the case laws. However, you may support or substantiate your contentions through that particular manner. Then what you can do is, you can in fact write down the factual arguments that I told you in the beginning, that which three to five factual arguments that I told you in the beginning to be made as the pivotal point of your arguments. You can depend upon the same. You can connect it logically to this particular contention, and that's how you can structure it in a well formatted way. And finally, make sure that you comprehend it in the best possible manner, because even if the judge is not going through all the pages, even if he's going through the last paragraph of your contention, he should be able to get it very clearly by your comprehension that as to this particular law is applicable to your case all because of this reason, and this is the factual position in your proposition which supports your case. Okay. While writing the submission, we need to be conversational, right? But how to make sentences more concise and avoid last-minute changes? This is what I told you. See, the arguments advanced in your memorial highly differs from the argument notes. You can be conversational in your argument notes to that particular length upon which you can substantiate your points. But when it comes down to writing the arguments advanced in your memorial, I would say rather than being much conversational about the contention that you are dealing with, you should be rather more relating it to the legal provisions and connecting it with the factual matter and then lay it down. You need not be that conversational when you write it down in your memorials, but you can be when you argue. When you do your oral presentation, you can definitely be conversational. You can definitely do that. And I will explain much of that details tomorrow when I give a lecture on that. Okay. And now the next question is, sir, how does one cite cases from Indian Kanun? In cases one finds a very useful case but doesn't find any citation for this. Okay. This is one thing I always want to tell the students of nowadays, the present generation. See, never take it for granted that anything that you cite from Indian Kanun is going to be treated with a much more authority, okay? Because I don't know, even if you cite it before the real courts of law here, they won't take it. What they depend upon is if it is from an SCC, if it is from AAR or a reputed law journal, reporter, then they will consider this. So what you can do is, you need to find out which is the case that you are looking for, whether it was decided by the High Court or the Supreme Court. You can go to the website of this particular respective high courts and also the Supreme Court, and they have free search option in their websites. You can depend on a lot many things, even if you don't have a citation. If you know the name of the parties, the appellant or the respondent, then you can find out the case, the citation from their websites. But provided you need to know which particular high court or whether it came from the Supreme Court or something of that sort. That will be a task. And if you could access anything of Manupatra like legal research journals, then I would say it would be much more easier, because they got a multiple kind of search options. You just give them the name, they will list out all the cases in their server with all those names, whether it be the petitioner or respondent. So that will be much more authoritative is what I feel. Sir, what kinds of expression and moves can you use while making arguments? Definitely, that is a thing which needs to be discussed in detail, which I will be doing it tomorrow evening in the last session for our topic. I'll explain it tomorrow. What if we have prepared something and at the spot, the scene is different, like it's not aligning the way we thought it to be? Adyasha Patnaik, if you could clarify what you wanted to know, it will be much more easy for me to answer. All right. So these are the
So
questions that I saw here.
I think what
Sir,
she
what is
wanted
the
to
most
ask was
appropriate
that.
method of citing a case? You always follow the standard format of citing a case. You might have seen in any of the books, any of the law books that you go through, you get to see, for example, if it is Keshavananda Bharati decision, they write it down like Keshavananda Bharati versus State of Kerala, year 1973, SC, so and so. That's how they are written down. If it's a Vishaga Mills versus Rajasthan, Vishaga versus State of Rajasthan, AR 1997, SC 597. That's how they write it down. That is the standard way of format. If you are following AR citation, otherwise you can follow the SEC citation also. Whatever it be, write down the case name, X versus Y, then the citation, whichever is given. So,
So
awesome content, you explained very nice. Sir, I have one question. What do I do if the facts in the moot problem are incomplete or otherwise unsatisfactory? This is where I told you never to presume the facts. It does happen, not often, but still it does happen at times that some mood problems are not that much balanced, or they might have left, one side a little vague in nature, or not completely organized or something. So what you need to do is, first you need, as I told you, first you need to study and research and be thorough about your mood proposition. You should find out n number of situations which supports your case. Okay, 3 to 5, even if I numbered like 3 to 5, n number of situations that support your case, whether it be the appellant side or be the respondent side. Then what you need to do is, you need to find out from that n number of facts supporting your side, which are the strongest. The strongest factual argument should be the one that you should be shooting first, because the judge will be going after the first argument that you will be citing rather than waiting for you to give your last argument. So make sure that you incorporate the best factual arguments in the first argument point itself. And now, coming to your question, if there is something unsatisfactory or incomplete in a mood problem, then what is it we can do? I would say, take it as a challenge. Take it as a challenge. I'm telling you this because I remember in my final year, when I won a mood, that time the mood problem was dependent upon a particular decision rendered by the High Court of Kerala in that particular year, 2012 it was. The matter was relating to the dispute of whether the fundamental right to movement can be done in violation of fundamental right to speech and expression. So the decision was very much in favor of speech, fundamental right to movement, saying that you cannot you cannot conduct political rallies and organize these jadas in the roads and public places, disrupting public movement. So the decision has come in favor of that. Okay. But see, just step into the shoes of that particular aggrieved party who might not have been happy with that judgment. Then what you need to do is, you may not have a case, precedent supporting your case. You will definitely have a latest precedent going against you. But still, if you got a client and you got to argue, what will be that last thing that you will find out for that person? Do that. That is my advice for this. If the mood proposition is incomplete or unsatisfactory, go find out the best possible arguments that you can come up with. Because always remember, whenever a new legal position has been established, it has not been established because of the reason the precedent said that. No. When the Nas Foundation case, in fact, was decided, saying that homosexuality may not be criminalized, it should be decriminalized, or maybe regarding the sexual harassment of women at workplace. So take n number of decisions which had put its mark in the legal arena. It had so taken place not because the precedent supported it, but because one particular lawyer, one advocate, or maybe a couple of advocates took it as a challenge, and they argued to their best possible capabilities, finding out the best arguments and the best factual things they could take it in their favor. Do that. Take it as a challenge. That's what I would say. Sir, how to integrate facts and legal arguments effectively? It's very clear. See, once you identify your factual issues, then you know what is the legal position that you have to look into. then look into that position. Find out that position, study that position, understand the position, research on it, and find out how it will help your case, your issue. Okay, and that needs to be done by applying your brain. You need to build a factual bridging or a connection or a legal nexus should be made between both the arguments. When you ask me as to how to do this, I'm telling you, you find out the best possible legal position supporting your case. Make sure you have the best factual argument from your side to link towards that. When you have both this, it's all about bridging them. You just need to argue that this is the legal position, this is the issue that you are facing, and your facts does generally support the legal position therein. So you need to get the grievance redressed through this method. That's how you do that. Sir, if a moot proposition is on an act that was amended and the cases are from before the amendment, how does one cite cases now? Leave cases. Why should you cite cases always? See, citing, that's what I have been explaining just before also. It is not always mandatorily necessary that you need to have precedents supporting your case. Think about that situation, step into the shoes of that particular client who wants to go about against the system, who wants to change something in the system. Okay, that is a challenge for a lawyer. If you are relying upon the precedents every single time, you're not doing anything from your side. So take it as a challenge, and you can do this. And how you can do this is to draft your arguments factually, as well as finding out the legal positions apart from the case laws. Even apart from the case laws, you will have the legal commentaries somewhere or something supporting your case. Go find it out. Maybe it will take 1 week to find out. Maybe it will take 1 month to find out. But make sure that you don't quit the game unless you find it out. Then definitely you will get the answer. Take it as a challenge and do this. You can do that. I'll explain much more when we deal with the oral presentations tomorrow. Dhyansha came with the clarification, I guess. I want to ask that, what if we have researched something that we thought is going to be helpful, but at the spot, suppose the argument is going somewhere else, which we are not prepared. Okay, again, I have a clarification needed as to what do you mean by that at the spot, the argument is going somewhere else. If you have drafted something, then you will be going accordingly. Did you mean that the judge will be taking you in a different direction?
So
is that what you meant through the argument going somewhere else, which you haven't prepared?
Sir, am I audible?
Yes, you are audible.
Hello. So I was saying that she might be asking that many times when we prepare an argument, we have a framework in our mind, but sometimes judges ask questions and the discussion goes somewhere else where we don't have the answer, or we are just trying to get to the answers, but we are not reaching there. We are just stretching it so that we do not just have to plead ignorance. So that's what she might be asking. Sometimes our arguments backfire on us. Many times it happens when there is a little loophole or something we have written but we do not have backed it. So then the judges ask repeated questions and they grill us. So that's what
okay. Now I get it. Yes. The judges generally do that. I will say, especially if you're dealing with an ex-mooter as a judge, he or she would definitely do that. They would definitely take you to a different, kind of arguments. They will definitely try to dissuade you from the framework that you have written down for your side, supporting your case. Okay. Even I do that as a judge. And I have seen large number of mooters who have prepared very well, very much thorough about this. They have tackling it very beautifully. But I have also seen people, stumbling upon that and getting all dissuaded and rejected because of the reason I just, deviated them from the main sort of arguments. But I would say never take offense at the judge for that particular doing. Because what you need to do is, this is what is supposed to be done by a mooter. I was planning to explain it much in detail during tomorrow's presentation. That anyway, I will answer the question for the time being. See, it is all about the persuasiveness or legal articulation that you can do. The judge may take you to a different point of law, or may give you a different hypothesis which may not even exist at any point of time. And what you need to do at that instance is, without violating any of the court etiquettes, without breaking any of the court manners, being very humble and polite. At the very same time, you should be able to take the judge back to that point of your argument where you wanted the judge to be hearing and judging you upon. You have to develop that skill, because nowadays you might feel that this is one thing which may happen just in a moot code, but this happens even in the real code also. And in a real code, you can't blame the judge always, because that won't help your case. If you want to get a particular order in favor of your client, you need to be, you might be the best advocate available, you might be the best researcher in your field, but whatever it be, if you need to take care of your client's interest, you should also be able to please the judge, please the court, without violating, code manners, as well as not without compromising your ethics. So that you need to know. I'll explain in detail tomorrow while as to how to prepare or present the oral rounds. Okay. Sir, memorial has to be prepared from both the sides. But when a counsel is proving a particular fact from the one side, how to disprove it from the side of another? It's very simple, because the best thing that you get to do to study a fact or a factual point is when you do a moot, is what I would say. Because I will explain. Because when you step into the shoes of a lawyer, litigation lawyer, what you do is you will be representing your client on one side only. Okay. So you will be aligning yourself to that one side. Maybe you will be the petitioner, or maybe you will be the respondent. But during this mooting, what you get to do is you are trying, you need to try to get into the shoe, step into the shoes of both petitioner and respondent, not at the same time, but at different times. But at that time, when you do that, if you step into the shoes of the petitioner, think from the viewpoint of petitioner, what he needs, what he or she needs in that through that petition, what is their grievance, what are the issues they wanted to be addressed in their favor. And once you, that's why I said you have to read the factual, facts, moot proposition n number of times, multiple times, and that will help you in writing down that pivotal 3 to 5 facts for both the sides. I do repeat that. When I said it in the beginning of the presentation, I did really clearly mention that when you start doing, working on the moot proposition, read it multiple times, find out 3 to 5 facts which goes highly in support of your case, both for the appellant or petitioner and the respondent. Once you're thorough with what is the factual need of your client, factual need of that side, that is the legal position in which you have to work upon. Then you can start finding out, supporting articles, journals, whatever it is. Hope you got that point clear, because I will say it in very, less words once again. If you are drafting the memorial of the petitioner, try to read the facts from the side of the viewpoint of the petitioner. Find out 3 to 5 facts which are completely in support of the petitioner. Then you frame the issues based on that. So now what you need to do is you need to find out the law supporting the claim. Go find out the law supporting that for the petitioner. Draft it. Get it done with. Maybe during the period of your research for the petitioner, you will come along all those stuff which might be helpful for the respondent. Keep it aside. Never throw it away. Once you're done with the petitioner, go for the respondent. If you can manage it, equally, then you do it together. But when you step into the shoes of the respondent, view the whole factual fact sheet or moot proposition from the side of the respondent. View as to why these issues raised by the petitioners shouldn't be allowed, should be defended upon. Write down those arguments factually. Then go and find out the legal thing which supports that. That will help you do that. Okay. Any more questions?
So I could not find in my chat box if you have in your
No, even I
personal
couldn't
chat
see
box.
it.
Okay, sir.
Anika.
So that's okay. So I have just one question
Yeah,
relating
please.
to the fact that when we write the facts from both the sides. So, for example, if there is a case relating to government taking a decision of internet shutdown. So, if we have mentioned that government took an arbitrary decision of putting a blanket ban and shutting down the internet. So if we are writing against the government, and so we can add such words like arbitrary and a deliberated and calculated decision while we are writing the facts to make the judge feel like that this is wrong and this particular they were right in doing so. So can we do such things?
You can do that. But what happens is, when you go beyond the limits, what happens is the judge will, it depends upon the judge. I can explain it from my viewpoint as a judge. I would definitely not leave that counsel, feel free right from the moment of the first moment they step in, because I will go after that word. I'll go as want the counsel to explain as to why he or she wrote down that word, and want them to explain their understanding of that word. Okay. And I will take them to some other level, which in fact my whole point of view is not to prove you wrong, but to take down your time, to take you into some other arguments which in fact waste your time. I will do it as a judge. Okay. What you need to do is you need to take it back to the main track wherein you want to argue. But keeping apart that particular fact, I would say it's better not to go into such matter of discussions or use such terms which may eventually lead you into trouble. If you are confident enough to defend those terms, then need not worry. You can proceed. But if you are not, I wouldn't suggest that you go for that.
Thank you very much, sir. So now I could not find any question in the chat box. So we are here towards the end of the question and answer session. I hope everybody has got the answers of their questions, as I can see in the chat box. So now I would like to invite Mr. Rupam Banerjee, the founder of the Amikus Qriae organization, to present a vote of thanks.
Thank you, Anika. Am I audible to you?
Yes.
Okay. Thank you, Anika, for the honor. I would take this immense pleasure in thanking this opportunity to render today's vote of thanks. I'd like to thank today's speaker, Advocate R.S. Visruth sir, for guiding us and laying down a brief about the topic and the memorial drafting and the voting skills in the oral rounds of the moot court competitions. I'd also like to thank all the participants for being so cooperative and for being so active. Lastly, I'd like to thank the team of the Amikus Qriae as well as Kalpesh Kumar sir for providing us the support with this, for all the efforts for today's session. And thank you all for joining the first day of the session and looking forward to more active participations in tomorrow's session. Thank you all. Thank you, sir.
Thank
Thank
you.
you, sir.
Thank you, sir. Thank you, all the participants. Now you can leave the meeting.